Hi, my name is Rochelle with WG Title, and today we're actually going to talk about an article posted on Realtor.com regarding nightmares that your title insurance policy could prevent. Now, this article is a little older, from 2015, but it is absolutely still relevant for today's standards. And there were 4 topics that really pointed out to me that I wanted to go over. So in this portion, second sellers, sometimes a distant relative or an ex-spouse may surface with a claim that they actually own the property in whole or in part, and that the seller had no right to sell it to you. If that happens, a judge could confirm the party's claim, which means you could be faced with buying them out, having to negotiate, or setting a bathroom schedule with a new roommate, says Mark Israel, President and Chief Counsel of MIT National Land Services, a title company in New York City, and say goodbye to that equity. Just real quick on that portion, yes, it is in New York, so of course Texas standards are going to be a little bit different than what New York is, although I would say that the majority of that statement is pretty true, in that if somebody were to come out and say that they actually lived at this property while they were potentially married to somebody, they got a divorce, and maybe the property wasn't mentioned in the divorce, because I've seen that happen before, as maybe couples own multiple properties and the divorce only mentioned their homestead and did not actually cover any separate property that was owned together, husband and wife, but, investment property that may be discussed was not mentioned in the divorce. So I've had that happen. And yes, in fact, it was found during the closing process. So luckily we were able to catch it prior to it closing, but the husband did have to come back and either sign a deed, or they could have gone back to their divorced attorneys and had it added in the divorce itself. A buyer could potentially be out their own down payment and any principal paid toward the house, says Dave Zawodzki, if I didn't mispronunciate that too badly, Senior Account Executive at Proper Title LLC in Northbrook, Illinois. Yeah, if that could potentially be the case. I guess it depends on the exact situation with title insurance. That's why you want to get it, because title insurance does help cover some of those things if it is found that it was a mistake on the examiner's end. But if it was something that was not found in the divorce, and this property, in this particular situation, if it were between ex-spouses and it was not in the divorce and that was not something title found, then yes, title would be able to cover it. But if it is insured by title, and it was something that was fixed prior to, then this situation would not, necessarily apply. I guess it just depends on whether it was missed or caught prior to it closing. If a judge rules in favor of someone staking claim to a house, the lender's title insurance policy will only pay for court costs incurred by the bank, and it will reimburse the bank for what you owe on the mortgage if the sale is deemed null and void. Zawodzki says, an owner's title insurance policy will cover your financial losses, such as attorney's fees and court costs, even if you have to move out of the house. That's very plausible. I would say that for Texas title insurance, that would apply in this scenario if it was something that was missed in this situation and somebody came out of the woodworks and did actually have claim to the property based on a judge's ruling. Hidden mortgages. Just as with liens, it's possible a title search might not uncover a mortgage until after closing because it was posted incorrectly with the county recorder, Israel says. Because the buyer received a clear title at closing, if an owner title insurance policy is in place, the buyer just has to file a claim and the policy will pay off that lingering mortgage, Israel says. Yep, and that would be true, because if it's something that, was not listed on title and we were able to clear title based on what our recordings found, that's correct. Now, whether or not the title insurance company will go to the county or the the entity recording that document incorrectly, that's differently, but the title insurance company in this scenario would be able to cover whatever was not listed on our records when we did search title. Unpaid taxes. Zawodzki says that even though a tax search might come up with no delinquent taxes on a property, that doesn't mean a buyer couldn't subsequently receive notification of delinquent back taxes after closing. And that bill could be heavy unless the buyer has owner's title insurance. An owner title insurance policy would pay for this, he says, because the buyer was given paperwork that indicated taxes were paid. Well, it depends on a lot of situations, but that would be the case if, let's say, Again, we're issuing title insurance, the tax certificates that we order that are required, during the process to make sure taxes aren't delinquent at the time, have been paid. Now, there is a clause in the contract, or in the TREC contract anyways, that does mention that if taxes after closing come out to show that there are back taxes due, and this also depends on the type of property you're purchasing, that is protected within the contract to where the title company is not responsible. So this could apply. It just depends on the scenario. Was it disclosed prior to, or was it something that was after closing? The point of purchase. Israel says a title insurance policy is issued the day of closing. It's paid for then too. The cost can't be built into the mortgage, he says. I guess it depends on your lender and the type of loan you're getting. I have seen some lenders able to wrap that into part of their loan. So it just depends on the type of loan you're receiving. The one-time premium cost varies by location. Every state regulates the price of title insurance, which is always tied to the purchase price and or mortgage amount, Israel says. That's true here in Texas. We do base our policies on the purchase price for an owner's title policy, and when you're getting a lender involved, it is based on the loan amount or mortgage amount, like he says. Even if the chances are low that past owners or old tax bills might surface, it's worth it to at least have a conversation with your attorney and or title company about title insurance. If you're on the fence about plunking down money for a policy, Israel suggests reviewing your finances. Ask yourself how you would handle the financial and possible relocation expenses if you were to suddenly awaken to a title-related nightmare. And that's very true. You never want to necessarily get into a home without understanding what the potentials of the past ownership had, and that is why title insurance is so important, because that's what our job is. We're there to review any prior ownership with title, as far as what's recorded with the county. Was there a divorce, or was there a deceased person potentially on title before that? All of those things could potentially be a nightmare for a buyer if title insurance was not involved. So due to the cost of the title insurance based on your purchase price, that is something you definitely want to consider if it is going to deter maybe you buying a property based on the purchase price. If you liked this video, don't forget to subscribe to our channel, or you can make a comment down below. All of our information is there if you did want to reach out to us personally, and we'll get you on the next one.